Before then, I will drop in the description a link to a Google Drive pre-class assignment for arrest, searches, and warrants. You are expected to look at the pre-class assignment. Maybe when I come next time, we will treat the pre-class assignment after I'm done teaching arrest, searches, and so welcome. This is counsel for the rich only. So now we'll be looking at criminal litigation. Now, if you are a 500 level law student, either you're a 500 level law student or you're done with university, you're about to enter law school. In fact, even if you're about to enter 500 level, because I think they teach criminal procedure and criminal litigation in your 500 level, or you're done with your 500 level, you're about to enter law school, Nigerian Law School, where you would do your vocational training, then this particular video is for you. Or maybe, depending on when you're doing criminal procedure in your school, maybe 400 level, some do it in 300 level, some even do it in 100 level, criminal and civil procedure. So depending on your school, but the whole content is the same. Yes. So we'll start with the introduction. Now I would be making reference to my notes so that, of course, you would be having the main gist of what we are about to discuss or what we are discussing. So today we'll look at the introduction of criminal litigation. We'll look at the scope. When you say criminal litigation, what is the scope? From where to where are you covering when you are looking at criminal litigation? This is very important so that you would know when to stop reading, or you would know where to start reading and where to stop reading, so that you're not going to read something that is outside the scope of criminal litigation and you are now wasting your time when you'll be reading all those ones that are not the scope of criminal litigation. Now we look at the sources. When we want to talk about the laws that guide criminal litigation or the rules, where do we look at? Now look at settings and settings of court. Settings and settings of court. When do court sit? How is the court? Most of you have not gone to court before, even though you're in the 500 level in the university, or maybe you're done with university, law faculty. You have not gone to court, you have not attended court before. So we'll look at the settings and settings of court. So if you have attended court before, the settings of court would not really be confusing for you. And this is an advice. Please, anytime you have any chance as a law student, no matter the level you are, go to court. Most of the times when you go to court, it will be boring. Yes. You might even want to sleep. In fact, you might sleep. In fact, go there and sleep. You understand? Go there if it's boring, sleep. Yes, and wake up and go home. Tomorrow come back. So you would get used to it. So we'll look at the introduction. First of all, what is an offense? I said here, offense simply means an act. Any act or omission which the law of the land forbids and against which the law prescribes sanctions or punishment. So for an offense to be an offense, the law of the land must forbid it, and it should also prescribe sanction for it. So if the law of the land just forbids it and does not provide any sanction for it, then you cannot say it's an offense. So the offense has characteristics, two characteristics. Number one, it must be provided for by the law. It must be forbidden by the law. And number two, it must have its sanctions prescribed against it. So that when they say wearing of clothes every Friday is forbidden, if you wear clothes any Friday at all, you would be arrested and charged to court, and when you are found guilty, you 2 years imprisonment. That is now an offense. Wearing clothes on Friday now becomes an offense because number one, it has been forbidden by the law, and number two, the sanction has been prescribed. Now, you look at section 2 of the criminal code, look at section 28 of the penal code. Take note of these sections. Look at section 371 of the Administration of Criminal Justice Law of Lagos State. Look at section 1 of the Administration of Criminal Justice Law of Kano State. And look at section 494 of the Administration of Criminal Justice Act. The one of Lagos and Kano are laws. Of course, when you did your legal method, you would have understood the meaning of acts and laws. Acts are made by the National Assembly, while laws are made by the state. Of course, we also have section 36 sub 12 of the Constitution, Federal Republic of Nigeria. You can also look at the case of Aoko against Fagbemi. So look at section 36 subsection 12 of the Constitution. Look at the case of Aoko against Fagbemi. You must have that particular act or action forbidden and the punishment prescribed against it. Of course, we have the divisions of offenses. This thing you would have done in your criminal law. We have felony, we have misdemeanor, and we have simple offenses. So a felony is that crime that has a term of imprisonment of 3 years and above, or above 3 years. Then misdemeanor from 6 months to 3 years. Then simple offenses below 6 months. So all these things, I'm just rushing it through because I am assuming that you've done it in your criminal law. So what is now the difference between criminal and civil litigation? Of course, this is criminal litigation. I will also start a series on civil litigation because these are the courses that you'd be doing in Nigerian Law School. So what is the difference, or what can you say is the dichotomy between civil and criminal litigation? Now we look at this dichotomy in subheadings, in different subheadings. Number one subheading is in the commencement. How are criminal proceedings commenced and how are civil proceedings commenced? So in short, criminal proceedings are commenced by the state, while of course you know that civil proceedings are commenced by individuals or companies. Of course, companies are persons under the law who have cause of action to commence that suit. It should also be noted that when you look at the civil litigation, you would see how cases are being brought to court. So now we've looked at the persons that can institute criminal and civil matter that is based on the subheading of commencement. First of all, we see that is the state that can institute matters, or police, depending. So when the police arrest you, or any enforcement agency, so the EFCC can also institute the criminal matter against you. The NDLEA can institute, the states generally. While in the civil aspect, it is the individual that has the cause of action that can institute this matter against you. Now we've looked at the person. Now let's now look at the mode. How is a civil proceeding instituted? Now, when you look at your civil litigation, you would see mode of originating processes. How do you originate process? How do you come to court? Number one, we have the writ of summons, we have the originating summons, we have the petitions, we have the originating motion. It's either you use any of them to start your civil proceeding. But in the criminal aspect, you only either use charge or use information. So the mode of commencement is different. So you look at the dichotomy of civil and criminal litigation based on the commencement, the person who commences, and the mode through which he commences. Now we also look at parties. While in criminal proceedings, the state is referred to as the prosecution. The opposing party is referred to as the accused or defendant. Now in civil proceedings, the person that is commencing the action is seen as the plaintiff or claimant or petitioner if you are coming through petition, while the opposing party is either seen as the defendant or the respondent, depending on the kind of matter that you are instituting. Now we've looked at the difference based on commencement, and under commencement we looked at the difference based on who commences and the mode of commencing. Now we've also looked at the difference based on the subheading of parties, and we have said that the parties in criminal litigation, they are different from the parties in civil litigation. We also mentioned that the parties in criminal litigation can be the prosecution and the defendant. Of course, we don't use accused again. While in civil litigation, it is either you call the person that is bringing the action the plaintiff, the claimant, or the petitioner, depending on what he's doing. So if he's coming through petition, you can call him the petitioner. You can even call him the applicant if he's coming through originating motion. While the person that is bringing that matter against is called the defendant or the respondent. I know why I'm repeating these things. Now, we go into the outcome of the proceedings. What do you expect to be the outcome of the proceeding in a criminal and in a civil matter? This can also form part of the difference. So what you see as the outcome of the proceeding, or what you expect to be the outcome of the proceeding in the criminal matter, is different from what should be ordinarily expected as the outcome of the proceeding in a civil matter. So in a criminal matter, we want the court to the prosecution would of course want the court to punish the defendant, while the defendant's lawyers on the other side would want the court to discharge and acquit. So in the outcome of the criminal litigation is either punishment comes or acquittal, discharged and acquitted. While in civil litigation, it is either the court fines for the plaintiff or the claimant, fines for him. That is, say that yes, he has a case, or he dismisses the claim. So in criminal litigation, is either conviction. Conviction is you are guilty, then punishment follows, or discharged and acquitted. While the outcome of a civil litigation is either the court finds for the plaintiff or the claimant, thereby making the defendant liable to maybe pay damages or do whatever it is that the claimant wants, or he dismisses the claimant's suit. That's when you now see that the defendant has won the case. Understand? So when the defendant say, I won him in court, he sued me, but I won him in court, then you know that they have dismissed the claimant's suit, maybe for lack of merit. So we also look at the standard of proof. To what extent are you expected to prove your case in either the criminal or the civil litigation? So it also forms part of the difference. Remember, we are still introducing it. We are looking at the difference between criminal and civil litigation. So under the subheading of standard of proof, what standard of proof do you expect to prove your case in criminal litigation? Now, in criminal litigation, when you look at section 139 of the Evidence Act, the standard of proof to be used in criminal litigation is beyond reasonable doubt. Beyond reasonable doubt. Now, when I am sure you've done law of evidence, and you have been open to the explanation of the meaning of beyond reasonable doubt. Now, beyond reasonable doubt does not mean beyond every shadow of doubt. But of course, you know that crimes have elements, and for you to be said to have proven beyond reasonable doubt is when you must have successfully proven all the elements of the offense without leaving anyone. So if you have now proven it beyond reasonable doubt, it's now left for the other person to disprove you, at least to put a doubt in the mind of the judge. If the defendant lawyer succeed in putting a little doubt in the mind of the judge, then you see that is when you see that they have acquitted and discharged the accused or the defendant. So reasonable doubt, beyond reasonable doubt, is the standard of proof in criminal litigation. While in civil litigation, you're expected to prove your case on the balance of probabilities, or what we call on the preponderance of evidence. Now, what does this mean? It means that when there is in fact, the court will imagine a scale of justice. There's an imaginary scale of justice where you would bring your case. You will put on your own scale, the other person will put on his own scale. Now, the weight of your evidence would now make the scale to tilt towards the person that the court will find for. So when we say preponderance of evidence, who has the weightier evidence? Notice I did not say who has the more evidence, because you might have hundreds of evidence and somebody will carry one evidence, and that one evidence will be heavier than your 100 evidence. So when you now put it on the scale and it tilts, your 100 evidence might not have the enough weight to tilt to your own favor, but that person has gotten just one evidence that will make it to tilt to his favor. That is preponderance of evidence. On this, see the case of Ajasin against Omobiriowo. Ajasin against Omobiriowo. That is the case you look at. Under the subheading of giving of evidence, when we are still looking at the distinction between the criminal and the civil litigation. Giving of evidence. Now, in criminal trials, the accused may choose not to give evidence or say anything at his trial, and his silence will not mean that he is guilty. Now, if you look at section 36 sub 11, Constitution of the Federal Republic of Nigeria, 1999 as amended, you look at section 181 of the Evidence Act, you would see that the right to remain silent is a constitutional right of the accused or the defendant. Forgive me for using accused, but it's for you to understand it. Of course, we do not call them accused. It is defendants we call them. When the accused chooses not to say anything in court, it does not mean, the court will not interpret his silence to mean guilty. However, in the civil litigation, when they serve you a particular writ of summons or a particular originating process, and you do not respond, you do not file your own statement of defense or your own reply to the petition, answer to the petition, or maybe your counter affidavit if it's an originating motion, then judgment will be given against you for default of appearance or default of pleadings. So even if I'm not doing civil litigation now, which of course will be done later in another series of civil litigation when I start the series, but it's better I make it clear to you now that when you are talking about declaratory reliefs, you cannot talk about default judgment, because court will not give default judgment when there is a declaratory relief. Now, for example, you want the court to declare a particular thing. You want the court to declare that a particular land belongs to you. You will be called upon. You have to bring motion to set the matter down for hearing so that you will now prove how the land now belongs to you in order for the court to give declaratory relief. So, mind you, if you fail to prove, even though the other person has not filed anything, the court will not give you that declaratory relief because you have to prove, of course, to the satisfaction of the court. Now, so let us go into the scope of criminal litigation. So, the reason I took my time to differentiate between the criminal litigation and civil litigation and give some kind of definition on offenses and criminal trials and all that is so that you would know when we are talking about criminal litigation, when we are talking about the scope of criminal litigation, what you should focus on. Criminal litigation starts from where and ends where. So it is important you know this. Number one, everything you'll be doing on criminal litigation as a course is within the scope of criminal litigation, as I will tell you now. So criminal litigation starts from the time complaint is laid to the relevant authority. So when you complain that somebody is committing an offense or somebody has committed an offense, criminal litigation has started. So you might complain to the police, you might complain to the EFCC, you might complain to the ICPC, just like Dangote. At the time of recording this video, Dangote complained to the ICPC that Engineer Farouk, I think the Director General of Nigeria Regulatory Upstream something, had paid about how many $1 million in a school in Switzerland for his children. So that petition, that complaint has kick-started criminal litigation. That is where it starts. Now, when the complaint is made, that complaint is expected to be investigated. I am taking it one after the other. So it starts with complaint, followed by investigation. Arrest is made. After arrest is made, they will bring him to court. Trial, they will arraign him. Trial will ensue. We continue. We start. After trial, conviction. Conviction, you are guilty. That is when this guy has proven his case. Then after conviction, sentencing. They are sentenced to 20 years imprisonment. After sentencing, appeal. If the person that was sentenced or was convicted wants to appeal, and that is where it ends, of course, and decision of the court that you have appealed to. That is where it ends. Of course, if you reach Supreme Court, so depending on the court you stop, that is where your own criminal litigation will stop. So if it reaches Supreme Court, there is no other courts to go to. So that's where. So it starts from criminal complaint. It starts from complaint to investigation to arrest to arraignment in court to trial to conviction to sentencing to appeal, then decision of the court that you have appealed to. Whether the appellate court oppose the decision of the lower court or whether it will dismiss them. So that is where the criminal is. So everything we'll be doing would be on this particular scope, within the confines of this scope. So there is no how we'll go outside the scope of this. The only time I just went outside the scope was when I was now trying to differentiate criminal and civil litigation. So we entered a little bit of civil litigation, which was not supposed to be, the scope of criminal litigation. But then it's for your understanding of criminal litigation. Before we go into criminal litigation proper, it is important we know the sources of criminal litigation, so that when we are trying to quote laws, when we are trying to look at the principle of things, of what should be done in a particular time or in a particular place, or how things should be done, what do we now look at? What is the source we look at? What is the law? Which laws do we look at in order to know what to do in a criminal proceeding or in a criminal litigation? Now, we have the principal enactment and we have the secondary enactment. So, sorry, we're looking at sources. We have the principal. If you can see this thing. So, principal and secondary enactments. We'll start from the principal enactments. So, principal enactments are like the most, when we talk about the sources of criminal litigation, this is where you go to first. This is like not like where you go to first, but it's like the primary, the most important. First of all, we look at the Administration of Criminal Justice Act, otherwise known as ACJA. Administration of Criminal Justice Act, I think it's 2015. ACJA 2015. We have the Administration of Criminal Justice Law. Of course, administration of criminal justice law of every state. Depending on the state you are in, you have administration of criminal justice law. I think all the states have adopted this administration of criminal justice law, if I'm not incorrect. Even though not all the states have adopted it, should just be one or two or three or four states that have not adopted the ACJL. But then, administration of criminal justice law of every state. But then, in law school, the ACJL, there's no how we will start learning the ACJL of all the states that have enacted ACJL for your study. In law school, the curriculum they are using is ACJL of Lagos and ACJL of Kano. Now, if your university is not teaching you with these curriculum, ACJA 2015, ACJL Lagos, and ACJL Kano, they are not preparing you for law school. Let me talk. Thank you. So, ACJL Lagos and ACJL Kano. Now, someone might ask, why is it that they can carry Lagos and Kano? Why not any other one? So, the Lagos here represents the south, while Kano represents the north. So, most of the times, when you even look at other ACJL of other states that are maybe in south, for example, Abia State, the ACJL of Abia State is as though they were copying the ACJL of Lagos, even though we had some little variations. But what you will understand is ACJL Lagos, the south, any state in the south that has the ACJL, look at it, it has similarity with that of Lagos. And while any other state in the north would most probably have similarities with that of Kano. Now, the ACJA 2015. Now, let us look at these three. Of course, this time Lagos is 2021, while Kano is 2019. Yes. So, ACJA, Administration of Criminal Justice Act of 2015, where does it apply? It applies to national courts or federal courts. So, when we talk about federal courts, we are looking at Federal High Court. We are looking at National Industrial Court. Yes? So, Federal High Court, National Industrial Court. Then, all the courts in Abuja, all the courts in Abuja, yes, they apply the ACJA. So, it is an act of the National Assembly. And because Abuja, the laws in Abuja is governed by National Assembly, of course, the lawmaking body of Abuja is the National Assembly. So the ACJA, which is an act of the National Assembly, is applicable to all the courts in Abuja. So the magistrate court that has criminal jurisdiction, the High Court of FCT, which is the High Court of Abuja, applies the ACJA. Now the Federal High Court anywhere, Federal High Court in Abia State will apply the ACJA. Federal High Court in Lagos State will apply the ACJA. Same with National Industrial Court in any state will apply the ACJA. So FHC, NIC, and courts in Abuja, ACJA. Now, the ACJL Lagos, of course, is applied by the High Court of Lagos State and the Magistrate Court. So the state courts, High Courts of the state and Magistrate Courts. The same with the ACJL in Kano. High Court of Kano State and the Magistrate Courts in Kano State apply the ACJL of Kano State. So the state courts in these states apply different states ACJL. So these are the principal enactments. Now we look at the secondary enactments, the 1999 Constitution, the Evidence Act, the Police Act, the Armed Forces Act, Coroner's Laws of the state, Children and Young Persons Law, Magistrate Courts Law, High Court Laws, Court of Appeal Acts, Supreme Court Acts, various court rules, practice directions, etc. So these are like secondary enactments. Now, these are the points to be noted. Listen and listen attentively. Under the ACJA, under the ACJA 2015, where there is a lacuna, what is a lacuna? A vacuum. A particular place that the court has not said anything about. When there is a lacuna, records should be had to procedure that will do substantial justice to the case. Where there is a lacuna, the court will look at what will do substantial justice to the case. That is in section 492 sub 3. Law school people. This is very important to you. This is for lacuna. When there is lacuna, record should be made to what we do substantial justice. In Lagos, When there is a lacuna, the court shall adopt such procedure which will, in its view, do substantial justice between the parties concerned. It is the same, of course, but people that want to get first class would see the difference in language. ACJA says recourse should be had to procedure that will do substantial justice to the case. Lagos ACJL says the court shall adopt such procedure which will, in its view, do substantial justice between the parties concerned. Now, in Kano, when there is a lacuna, local laws are to be looked at for possible legal solutions. So you now see that Kano is not saying what will we see to do substantial justice. What Kano is saying is that local laws should be looked at. So for Lagos, it is section 262. You should be writing when, if you're not writing and you're listening to me, just looking at me, maybe you're lying down on your bed, crossing your leg, you're doing yourself. So section 262 of the Administration of Criminal Justice Law, Lagos State, is what, when there is a lacuna in Lagos, then when there's a lacuna in Kano, that local laws should be looked at, is section 467, paragraph G of the ACJL Kano State. Now, it should be noted because they might ask you this thing now. They might ask you this thing in your exam. They will now paint a scenario of court martial. A particular military person did something, blah, 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 and they brought him to court and they have sentenced him. They use the ACJA rules. The ACJA, the Administration of Criminal Justice Act, does not apply to court martial. It does not apply to court martial because it's a court with special jurisdiction. Another point to be noted is that an offense created by the National Assembly may be tried anywhere in Nigeria, provided that in the course of such trial, the ACJA shall be applied and not the ACJL of the state which it is tried. The ACJA applies to acts of the National Assembly and any other offense punishable in the FCT. See section 2 sub 1 of the ACJA. So what does this mean? It's saying that if there is an offense that is against an act of the National Assembly, which of course can probably be tried in a court other than the FHC, that's the Federal High Court. So there are some National Assembly laws that might provide that a particular offense against that law or that act can be tried anywhere, not just the Federal High Court. So when it is being tried, maybe let's say in the State High Court, what should be applied is not the ACJL of that state, but the ACJA. So we've now looked at another place that the ACJA can be applied. So remember I said that the ACJA can only be applied to the Federal Court, just like the Federal High Court, the NIC, and courts in Abuja. But if there are other courts, state courts in other states that is trying a particular offense that is against an act of a National Assembly, the ACJA will be applied, even though ordinarily that court is not supposed to apply the ACJA in any of the offenses, just like the state high courts in ACJA or Lagos State. So if they are trying to if they are trying a matter that is the offense is against the act of a National Assembly, then we will use the ACJA. And that is in section 2, subsection 1 of the ACJA. Now we look at courts, types of court. Types of court. Before we look at the sittings and the settings of court. Types of court. We have courts of general criminal jurisdiction. And we have courts of special criminal jurisdiction. Remember, we are looking at criminal litigation. You understand? So, courts of general criminal jurisdiction are empowered to try and adjudicate on any criminal case. And they are only limited by acts or laws that are creating them. Examples are the Supreme Court, the Court of Appeal, the High Courts, the Magistrate Courts, customary courts in the south, the upper area courts, and area courts in the north. Now listen and listen attentively. When we will be looking at civil litigation and we'll be looking at jurisdiction, of course, when you even looked at jurisdiction in your university, you would see that they say that appeals from the customary court goes to the customary court of appeal. Yeah? While appeals from the area courts goes to the Sharia courts of appeal. Listen and listen attentively. The Sharia court of appeal and the customary court of appeal do not have criminal jurisdiction. Which means, if there is a particular criminal matter that the customary court is treating, you cannot appeal that criminal matter to the customary court of appeal. So, courts of special criminal jurisdiction. Of course, we said we have the courts of general criminal jurisdiction and we have the courts of special criminal jurisdiction. Now, these courts of special criminal jurisdiction are empowered to try and adjudicate specific offenses. Example, we have the Federal High Court. So when a particular act is saying that it is only the Federal High Court that has powers to try any offense under this act, specific. Federal High Court, we have the National Industrial Court, of course. Those are specific offenses that have to deal with industrial matters. Then we have the Juvenile Court for children, specific. We have the Courts Martial for the military, the armed forces, and other tribunals established under the law, such as the Code of Conduct Tribunal and the Robbery and Firearms Tribunal. So these courts or tribunals are courts of special criminal jurisdiction for specific offenses or for specific offenders. So we look at the sittings of court. When we look at the sittings of court, we're looking at which days are courts supposed to be sitting. So the days that courts are supposed to be sitting are what we call the juridical days. When and where are juridical days? We have juridical days Mondays to Friday. Monday to Friday are juridical days. See section 52 of the High Court Law of Lagos State. Monday, remember we are using Lagos and Abuja, then Kano. Mondays to Fridays. Now the non-juridical days are when courts are not expected to be sitting. We have the Saturdays, Sundays, and public holidays. Then vacation period, week before Easter. etc. Listen, because they might come in your scenario question in your exam and say, they held a particular proceeding on a Saturday or be on a Sunday after church, and this one happened. Comment on the validity or otherwise of the sitting. Legal proceeding held on non-juridical days amounts to a nullity, which means it is as though you people did not do anything, people wasted time. It does not hold water. It amounts to a nullity. See the case of Balogun against Odumosu. However, listen attentively. It has exceptions. So when it comes under the exception, you cannot say it amounts to a nullity. So what are the exceptions to the fact that when you hold proceedings in non-juridical days, that it becomes a nullity? When will it not become a nullity? That's what we are saying. So non-juridical days, you're not supposed to hold proceedings then. So because if you hold proceedings in non-juridical days, it becomes a nullity. But what are the exceptions? Meaning, in what circumstances will you hold proceeding in the non-juridical days and it will not amount to a nullity? Number one is when the parties agree. Agreement of parties. On that, you see the case of Osos and me against COP, Commission of Police. So, when the parties agree that CO, let us come back. Agreement of parties on a Saturday, on Sunday. Because of me, this case have prolonged for a very long time. Let us come back on Saturday, Sunday. Let us do this thing once and for all and leave here. When the parties agree, then you cannot say that it was held on a Sunday or in a public holiday, so it amounts to nullity. No, it comes under the exception. Agreement of parties will make it to be, valid. When statutes authorizes it. So when a law authorizes that you can do a matter on a non-juridical day, then it's okay. Example of this is section 40, subsection 2 of the Magistrate Court of Lagos State. Now, under the Magistrate Court of Lagos State, section 40, subsection 2, it allows for magistrates to sit on Saturdays for bail and remand orders and non-custodial disposition. So when you read section 40 sub 2, and you have to have it on your head, because it can come also as a scenario question, so that you would remember the principle in order to attack the question. Again, election petition matters. You can have it on non-juridical days because of the time frame and all that. Now, when we look at the settings of courts, when we look at the courts, we will find out that we have the bench. What is the bench? Where is the bench? The bench is where the courts or magistrate sits. So, sorry, I said the courts. The judge, of course, the judge is the court. So, wherever, in fact, let me even tell you this. Wherever the judge is sitting is the court. Even if the judge is sitting under the mango tree, even if the judge says, today I'll be sitting in my toilet, that toilet is now a court. And anything that you do that is bad in that toilet can be taken as a contempt of court if it is something that should even be a contempt of court. So you cannot say contempt of toilet, because we are not in the court. As far as the judge is sitting in his official capacity, anywhere, that place is the court. But now we are looking at the settings of an actual court, yeah? So the bench, this is where the judge or magistrate sits. That is, we call it the bench. Of course, you know, if people that have gone to court would have known where the bench is. Now, the registrar's desk is where the registrar or the court clerk sits. And it is usually in front of the bench. Yeah, it's in front of the judge. So the judge is facing you people. That's the bench, and it's usually in an elevated place. So while the registrar's desk is usually below. Understand? So the judge is as though he or she is on the stage. Yes, he's on the stage. It's usually elevated, while the clerk is, on the ground, but in front of the judge. The bar, this is where lawyers who are ready for litigation business sit. They must be robed. Of course, robing is not compulsory in the magistrate court. Rule 45 of the ROPC provides for robing in High Court, Court of Appeal, and Supreme Court. So Rule 45 of your rules of professional conduct would tell you how to dress in any court you are going to. So once you are properly dressed, of course, if you are not properly dressed, it will be said that you are naked before the law, and you cannot sit at the bar if you are not properly dressed. So as a lawyer, even if you're a lawyer, you cannot sit at the bar if you are not properly dressed. So when you are robed for courts that you are expected to be robed, the bar is where the lawyers sit that are ready for the day's business. Now inside the bar, we have the inner bar. The inner bar is meant for the SAN, the Senior Advocate of Nigeria, the Attorney Generals, and life benchers. Why other bar is meant for other lawyers like I've not reached SAN. Now, if a court does not have an inner bar, the first rule of that particular court is meant for these people I mentioned, the SAN, the Attorney Generals, and all that. Now, the dock is different from the witness box. The dock is usually where the defendant sits or stands in. So when they call the defendant, he enters the dock. Of course, it does not, whether it's on the left or in the right hand side, depends on the court. But then the notes I have here says it is to the left hand side of the judge. An accused cannot give evidence from the dock. He can only make a statement of which he cannot be cross-examined, as it is not evidence. When an accused person wants to give evidence, he will move to the witness box. So the dock is where this accused is staying, the defendant stays. So any statement he makes from the dock, it goes to no issue because it is not cross-examinable. So if he wants to make a statement that he wants the court to use, he now goes to the witness box, where he can now be cross-examined. Then we have the witness box. This is where the witnesses stand to give evidence after they might have sworn to an oath or affirm. This is to the right-hand side of the judge. The witness can decide not to swear on an oath and still give evidence. See section 207 and 208 of the Evidence Act. So the witness box is where the witnesses, people that want to come and give evidence, give testimony on what happened on that particular day. This is where they enter. Of course, depending on the court, it does not really have a particular place, but for the purpose of your exam, it is to the right-hand side of the judge. The witness can decide not to swear. The witness can say, my religion forbids me to swear an oath, but he can still give evidence. See section 207 and 208 of the Evidence Act. Now, the gallery is where people like you that are watching me will sit, because you are not a lawyer yet. And even though you are a lawyer, if you are not properly dressed, you are going to be in the gallery. So, for the introduction of criminal litigation. So when we next will come, we'll look at arrest, searches, and warrants. But before then, I will drop in the description a link. I don't know if it's going to be possible, but a link to a Google Drive pre-class assignment for arrest, searches, and warrants. You are expected to look at the pre-class assignment. Maybe when I come next time, we will treat the pre-class assignment after I'm done teaching arrest, searches, and warrants. Until I come your way next time, safe.